If you and your spouse decide to get divorced, what happens to any inheritance that you've received or might receive in the future, or any assets that you owned before you were married? Do these automatically get split down the middle between the two of you? Well, I'm here talking with solicitor and director Fiona Wadey to find out more about these things and how they might have an impact on the financial agreement element of your divorce. Hi, Fiona.
Hi.
Could you start by letting me know, is it a done deal that when you get divorced, everything gets split down the middle between the two of you or not?
No, in truth, there's no straightforward answer. There are a number of factors that need to be considered before a final decision can be made, to include the needs of both parties and any children of the family, the length of time that you've been married, the standard of living that you enjoyed as a couple, and whether there is a pre- or post-nuptial agreement in place. It might also be the case that some of the assets that you have, you owned before you got married, in which case there should be a discussion regarding that. Essentially, the court's intention is to be fair to both of you.
Okay, and what sort of assets might be referred to as premarital then?
So you might have a property that you owned before you got married that you then retained as an investment, or perhaps you have a savings portfolio that you've been paying into for a long period of time, or similarly with a pension. Or you might be a farm owner or have a long-standing business. They're all different examples of premarital assets, which essentially represent a contribution made by one party, unmatched by an equivalent contribution by the other.
Okay, and here's one of the big questions. So, is it fair that when someone receives inheritance, that gets split between both parties?
A lawyer is likely to argue that an inheritance represents a non-matrimonial asset and so shouldn't be considered as part of the marital pot of assets to be divided. But there are a number of considerations here. So how long have you been married? If you've only been married a short time, then the inherited asset is likely to carry greater weight. How much was the inheritance? When was it received? And what did it consist of? It's also important to think about how the inheritance was used. So if, for example, it was used to pay off part of the mortgage on the family home, then it's more likely that a court would consider it to form part of the marital assets because it's being commingled. The court will look at the financial needs of the couple and whether they can be met from the family assets without recourse to the inherited asset. But if it seems that those needs can't be met without using that, then it's unlikely that a court would allow one party to retain the inheritance, and they would instead need to share it with their spouse in order to meet their needs and those of the children.
Okay. What happens if one of the divorcing couples is going to receive a large inheritance in the future?
Okay, so that's quite a complex question, just because while the court will look at the assets of the marriage on the date that the financial proceedings come before the court, rather than an unspecified date in the future, they will look at both current and future needs. A court may take your future inheritance prospects into account when looking at both parties' future needs, because they are able to look at the resources that may be available to each party in the future. But there's quite a difference here between an inheritance that is definite from somebody who's recently passed away and an expected inheritance from somebody who is still living. Of course, a will can be changed right up to death, which means that inheritance isn't certain. And so, as a result, a court is probably unlikely to want to rely on it and include it as part of this financial settlement.
Okay, so is it possible to ring fence any inheritance or premarital asset?
There are ways to make it less likely that such an asset will be included as part of the financial settlement, but they do require a bit of planning and forethought. So keep the asset in your own name and separate and away from any joint assets. Don't use the asset or any income from it for joint or family benefit. And you could enter into a prenuptial or postnuptial agreement.
Okay, cool. And finally, what would you say is your advice to deal with such a situation if the couple do decide to pursue a divorce?
I think it's important to get advice as soon as you realise that sadly your marriage has broken down, because the courts will deal with cases involving inherited and premarital assets in quite a fact-specific way. Timing is key here, really, because if you get that early advice, then thought can be given to the considerations I've just mentioned.
Thank you. So as Fiona has explained to us, any divorces that involve inherited assets can be very complex. So it is crucial that you seek experienced specialist advice to get the best outcome for you and your family.